Okay, good morning, everybody. We'll get started now. Everyone can see my screen, I hope. So thank you for joining me this morning for a training on the ILS Parent Representation Semi-Annual Report, what we call the PRR-195. For those of you who don't know me, my name is Riley Weinstein, and I'm the Family Court Senior Research Associate at ILS. I also have my colleague, Bethany Simpson, joining me today. Bethany is the ILS Data Outreach Officer and will be monitoring the chat box during the training. Thank you, Bethany. We also have joining us members of the ILS Family Court Representation Team, who I'm sure will be happy to jump in and answer any potential more complex legal questions that may arise. Today's training will run for approximately 1 hour, and it is being recorded. It will be available on the ILS website in a couple of weeks. We have a lot of material to cover today, so I have designated question breaks built into the presentation. And to keep us on track for this 1 hour meeting, I'd ask that you please hold your questions until these breaks or enter them into the chat. And any questions that you do enter into the chat will be responded to during those designated breaks. And of course, if you have any questions that we don't get to during the training, we will be sure to follow up with you afterwards. I'd like us to think of today's training as sort of an orientation to the family court data reporting to ILS. We did send everyone a copy of their county's budget and work plan in advance of this training. And if you have access to that now, I suggest pulling it up so that you can refer to it throughout the training. If you don't have access to this document right now, that's also fine. The training will still be informative and you can always go back later. You have already received a copy of the training slides. After the training, you will receive the remaining supplementary materials that I will mention throughout the training today. So essentially, today is about familiarizing yourselves with the family court reporting process and the core components of the PRR-195. We will not go through every question on the report. And as such, we do welcome and encourage providers to reach out after the training to set up individual data collection meetings and consultations as you work to expand your data collection. So to give you some background on the PRR-195, the report was first implemented last August in 2024, the impetus being to systematically collect data pertaining to the ILS Family Court grant funding, both via the model offices and the family defense grants. This report was developed collaboratively with the ILS Family Court Representation Team and also with county-based providers, including members of the Parent Representation Advisory Council. The PRR-195 is based on the initiatives highlighted in the ILS request for proposals for the family court grants, the ILS standards for parent representation, and the ILS caseload standards for parent attorneys. There have been some big shifts in the last several years for family court representation in New York State. And as such, now is an especially important moment to expand family court data collection. As you can see here, each year over the past 5 years, New York State has seen a significant increase in the amount of state funding allocated to counties for quality improvement in family court representation, from an allocation of just $2.5 million in 2021 up to $25 million now in 2025. These funding increases have enabled ILS to issue family court grants to an increasing number of counties, from just 2 counties in 2021 to now 42 counties and New York City in 2025. The expansion of the funding brings us to a critical moment for data. With systematic data collection in family court, we can track over time the implementation of quality improvement and caseload reduction initiatives in family court representation. We can gain insight into funding and practice needs and identify areas for continued improvement. And ultimately, these data enable us to highlight the value of continued state funding, state investment in family court representation. Despite these critical increases in allocated family court funding, there are many challenges involved in the systematic collection of family court data. First, there are the implementation challenges, which exist across the state but vary by county. One challenge, for example, may be getting county approval to create a new position under the grant funding. This process sometimes can be quite time-consuming, causing delays to implementation and stalling the data collection process. When it comes to data collection itself, there's a need to update existing practices and case management systems to come into alignment with the family court reporting requirements. Currently, you may not track much family court data. It may be very limited in scope, and that is expected, given that up until now you have not been asked to report these data. So the information I share today will be likely all new and potentially a little bit overwhelming, so I do want to be clear. ILS understands that reporting complete data on the PRR-195 requires dedicated time. It will not happen overnight, but it will happen in stages. So we simply ask that you work in collaboration with ILS to progressively expand your data collection to ultimately be in alignment with the PRR-195. Before we get to the PRR-195 form itself, I want to quickly introduce you to the implementation memo. This memo is a one-time summary of the steps your office has taken to implement your grant-funded project. The steps will look different for each provider depending on the nature of your grant-funded project and also the county-specific processes of implementation. So to provide an example, you may describe in your memo the process of developing and filling a new position under the grant. What was the county approval process like for the position? How did you recruit qualified candidates? The memos can be submitted individually by provider, or if multiple grant-funded providers within a county would like to collaborate, a joint memo can be submitted for all grantee providers within that county. Please email the memos to the Family Court Data inbox. The address is listed here, fcdata@ils.ny.gov, or you can submit them as an attachment to your first PRR-195 submission. The deadline for those implementation memos is March 2nd, 2026. Now, getting to the reporting form itself, the PRR-195. This is to be submitted by each provider office twice per year, once in August and once in March. While the August report covers the first 6 months of the current calendar year, the March report covers the entire prior calendar year. So in other words, the August report is the 6-month report and the March report is the annual report. As recipients of the 4th ILS Family Defense Grant, your first PRR-195 is due March 2nd, 2026, and it will cover calendar year 2025. To varying extents, 2025 is sort of an implementation startup year for recipients of the 4th Family Defense Grant, and thus you will likely not be able to provide complete data for calendar year 2025 due to hiring potentially still being in progress and also likely still updating your data collection, which again, that will take some time. Thus, the goal for 2025 data is to prioritize the core data points, which we will identify today, and from there, we will work together to expand your data collection to other sections of the report. Are there any questions at this point?
Nothing yet in the chat.
Okay, great. So up here on the screen are 3 documents that I'd like you to begin familiarizing yourself with, as they will be very useful as you prepare for submitting your PRR-195. First, we have the definitions for reporting parent representation caseloads to ILS. So these are the definitions that are embedded within the reporting form itself, but they're also centralized within a single document. And it's important to reference these definitions when reporting to ensure consistency in counting petitions. Next, we have your grant contract, which contains your budget and work plan, the documents that I sent you in advance of the training. The budget provides the total dollar amount allocated to each aspect of the grant. For example, the salary amount for a new social worker position. And the work plan provides a narrative description of this grant-funded position. So for example, it might say something like, the social worker will connect clients to community-based resources. Both documents will inform how you respond to certain questions on the PRR-195. And lastly, we have the data reporting tips document. So this, which you will receive after the training, is a quick reference guide that you can use to sort of cross-check your totals within the report. For example, there will be a hint like the total in number 33 should match the total in number 24. So thematically speaking, there are 4 core components of the PRR-195, and these components are in alignment with the funding initiatives. First, we have timely access to counsel. Then we have caseload relief. Next is interdisciplinary representation. And lastly, we have training. And these themes will ultimately guide the remainder of today's presentation. So we'll start with timely access to counsel, which refers to the initiative to provide parents with representation as soon as possible before court intervention. Timely access is operationalized through what ILS terms investigation representation, or IR for short. IR, the definition is the legal advice or representation that providers give to clients during the CPS investigation phase of a case before a petition is filed in court. So the first substantive section on the PRR-195 is the IR section. Question 4 up on the screen here asks whether your office provides IR under the Family Defense Grant. To determine whether your office does provide IR, you can check the work plan. I'd suggest looking for terms such as early access or timely access. If you see these terms included in the work plan for your provider office specifically, select yes, and you will automatically proceed to the rest of the IR section of the report. And if you say no, you will automatically skip that whole section. As a note here, if your office is funded to provide IR but has not yet implemented IR, you should still respond yes to this screener question because there will be some follow-up questions. If you do provide IR, you'll be asked a series of questions about this representation during the reporting period. The core data points here are the total number of IRs opened, closed, and pending. So when you go to answer these questions, please pay attention to the instructions and definitions to ensure that you're reporting accurately. As you'll notice, most questions in the IR section refer to IRs closed. So I want to spend a little bit of time talking about how we define an IR as closed. For ILS reporting purposes, an IR must meet the following criteria to be considered closed. A, CPS does not file a petition and affirmatively notifies the client or the provider that they will not be pursuing court action at the conclusion of the investigation. This, in some counties, doesn't always happen. You may not have that affirmative notification. So B says, or CPS does not file a petition within 60 days of commencing the investigation. Or C, CPS does file a petition, and in this instance, the provider should close the IR and open a new neglect or abuse petition in their case management system. The second core data point in the IR section pertains to the outcome of the CPS investigation. There are 2 overarching scenarios here. One is an abuse or neglect petition is filed, and 2, an abuse or neglect petition is not filed. If a petition is filed, make sure to distinguish whether it is an abuse or neglect petition. If a petition is not filed, if possible, please distinguish whether the allegations were unfounded or indicated. as an indicated report, even in the absence of a petition filing, carries consequences for clients, such as job loss, for example. However, if you are unable to distinguish indicated from unfounded in this scenario, but you know that a petition was not filed, please still count it as not filed and just specify that it's unknown whether the allegations were indicated or unfounded. Okay, also under the Timely Access to Counsel initiative, some providers have Family Defense Grant funding dedicated to a public outreach program, which aims to inform the community about the availability of IR. So question number 18 on the PRR-195 asks you to indicate whether or not this funding is a part of your work plan or budget. So to determine this, please check your budget. You can look under OTPS. There's a header called OTPS, which stands for other than personnel, and look for terms like public outreach campaign or community outreach. If you do have these terms, you should respond yes, and then you'll proceed to answer a few questions about your public outreach. If you respond no, you'll skip to the next section. And again, if you have the funding in your budget but have not yet implemented it, please still respond with yes. Another screener question under the Timely Access initiative is in regards to an on-call line. Some providers have funds in the budget dedicated to the establishment and maintenance of a dedicated on-call line to screen and accept referrals for investigation representation. So to check if this is relevant to your office, look again at your budget under OTPS and see if there are any terms like on-call rotation or hotline, and then you can respond to this screener question accordingly. Do we have any questions at this point?
Nothing in the chat.
Okay, thank you. The next section is on the office-wide attorney caseloads in family court. Although the ILS grant focuses primarily on the child welfare proceedings, it's important to collect data on overall caseloads in family court, as this impacts the Article 10 work. Thus, all grantees, regardless of work plan, are required to report family court caseloads to ILS, ultimately in alignment with the family court caseload standards. The goal of calculating family court caseload standards for grantees at this point is not to assess compliance with the caseload standards, but rather it is to quantify caseload need. I have listed here the 13 petition types according to the ILS caseload standards. The PRR-195 requires that you report totals by petition type for petitions open, closed, and pending during the reporting period. It's really important to properly categorize the petitions, as each type is assigned a weight based on the average minimum hours that it takes to complete representation on this type of petition. So the recommended caseload limit is 300 weighted petitions per attorney per year. And I won't go into too much more detail, but if you are interested in learning more background about how petitions are weighted, I encourage you to look through the ILS Family Court caseload standards. Often in the first rounds of reporting, providers are unable to report complete data in every category, as they are in the process of updating their data tracking systems. And relatedly, there can be some inter-county differences in docketing, so it can take time to align your data collection with the ILS petition categories and definitions. So if you have missing petition data in the first rounds of reporting, there will be an option to select unable to report. So you can do that and then provide a brief explanation in a comment box that will be a part of this section. Specifically, number 26 is the comment box question. To give you an example of the value of accurate petition level caseload data, up on the screen I have a chart that's based on the weighted caseloads for institutional providers in calendar year 2024. As you can see, the most common caseload range is 601 to 900 weighted petitions per attorney. Notably, this is 2 to 3 times the recommended caseload limit. So without accurate caseload data, we may feel the weight of high caseloads, but we would not have this quantitative evidence to support it. And that is why collecting this information accurately and systematically is so crucial. In addition to the petition information, you'll also be asked to report data on family court attorneys. If you are an institutional provider, you will be routed to question number 27 on the PRR-195, which asks for the total number of full-time equivalent, or FTE, attorneys who provided family court representation in 2025. And of those family court attorneys, how many provided Article 10 representation? For those of you who may not be familiar with the term full-time equivalent, I'll give a quick example. If one attorney splits their time 50-50 in family court and criminal court, they would be counted as a 0.5 full-time equivalent in family court. And then if half of that time in family court is spent on Article 10 representation, that would be 0.25 FTE for Article 10 representation. Now, these, to a degree, may have to be estimates. It may not be exact, but as close to accurate as possible is greatly appreciated and important. For assigned counsel providers, on the other hand, you will be routed to question number 28, which asks for the total number of attorneys on the panel who provided representation in family court matters in 2025. Excuse me, in 2025. Any questions?
Yes. We have a question in the chat from Scott Banks. He is wondering, why do I need to report caseloads when I am not hiring attorneys under this grant? I hired a paralegal and a parent advocate.
All right, great question. So the reason for that is, as I mentioned, it is really important for ILS to be able to quantify caseload needs. So reporting the caseload information helps understand your workload. That is of course impacts and relates to Article 10 representation, but it also provides that quantitative evidence for the need for continued state investment in family court representation.
Okay, I believe we are done with chat questions.
Okay, thank you. If there are no other questions, I will keep going. Okay. So the next 4 slides contain some frequently asked questions. So I will start with number 1. The question is, I can't determine whether the Article 10 petition is an abuse petition or a neglect petition. How do I count it? The answer is that if the petition contains both abuse and neglect allegations, you should count it under abuse. However, if you are unable to distinguish whether it's abuse or neglect due to data entry issues, please enter the total under neglect and then provide an explanation in that comment box in question number 26. Okay. The second FAQ is, my county generates a new petition/docket number for each child involved in the Article 10. Do I count each child as a new petition when reporting to ILS? The answer is that if the dockets/petitions originated from one Article 10 filing and are heard together, this counts as one petition. Number 3, this pertains to when a petition is considered closed. So the question is, a dispositional order was issued, but there are still court dates scheduled every 6 months for the permanency planning hearings. Is this petition still considered closed? The answer is yes. For ILS reporting purposes, a petition is considered closed administratively once the dispositional order is issued, even if there are ongoing permanency hearings or review dates. While the attorney still may attend hearings, the active litigation phase has ended. And from a data perspective, waiting until all review hearings have ended would significantly delay our ability to capture data, sometimes by years, and would prevent timely analysis. The last FAQ here it pertains to when multiple petitions may be disposed with a single order. So the question is, a client's Article 10 petition was resolved as an Article 6 custody and visitation petition. Do I categorize this as an abuse neglect or as a custody/visitation? The answer is that you would count each petition based on how it was originally filed, even if they were resolved together with the same final order. In this scenario, you would count one abuse or neglect and one custody/visitation. So that would be 2 petitions total. The third thematic component of both the grant funding and the PRR-195 is interdisciplinary representation. This refers to the collaboration between an attorney and other types of professionals, from caseworkers to experts who contribute to the defense. ILS uses the term specialized services to refer to these professionals. Specialized services may be provided by a salary position, for example, like an in-house social worker, and also by vendors retained on a per diem basis, for example, an expert. To check how specialized services may be a part of your ILS grant-funded project, you can again look at your budget. The first place to look is under personnel. In this sample budget, you can see that there is a line for the social worker/family advocate. The second place to check is under contracted/consultant. And in this example, you can see here that there is, in fact, a line for specialized services. Reporting on specialized services will happen in various sections of the PRR-195. The key here is to pay attention to whether the question is asking about grant-funded services specifically or the use of specialized services more broadly. For instance, you can see here in number 16A, it specifies grant-funded, and it asks you to summarize how these services are utilized and how they impact representation. On the other hand, questions 15 and 16 on the report simply ask for the total IRs and Article 10s closed and which a specialized service was utilized. To simplify reporting, you don't have to distinguish between grant-funded and non-grant funded services. This can become very complicated, especially if it's partial funding and different funding streams for one position. So instead, you can simply provide the total number of IRs and petitions closed in which the service was utilized. The important part is to specify by the type of service. For example, was it a social worker? Was it an expert? Maybe both. Okay. The next 2 slides are a pair of questions on the PRR-195 that ask for the position level information about grant-funded hires. One question refers to the specialized service positions, and this is the one I have up on the screen. And the other question refers to the attorney positions funded by the grant. As always, to determine whether you have a grant-funded position, you check your budget. Most positions, especially for institutional providers, are found in the budget under personnel. However, you should always be sure to check under the contracted/consultant section as well, as there are instances where attorneys or specialized service positions may be providing services as an independent contractor. As you can see in the slide here, the formatting for these grant-funded position questions can be a bit intimidating or overwhelming at first glance. So I want to bring you to the next slide to break this down a little further, step by step. Okay, so when you're going to answer question 39, you have to fill in those 6 columns, right? So the first step for the column 1 is to select the petition type from the pre-populated list of types of specialized services. If you have funds but for a specialized position but have not yet filled the position, you can simply select no specialized professional hired. And if you don't have this as part of your grant, you can just skip this question altogether. Step 2 is to select the start date for that position. Note, this is the start date of the first specialized professional to occupy the position. In other words, let's say the first caseworker started on April 1st, but left in May. Then a second caseworker started July 1st and still remains in that position. regardless of the change in who is occupying the position, you should still put April 1st in this scenario as the start date, as this is when the position started. Step 3, indicate the type of hire, whether new, an upgrade of an existing, or on contract. While a new hire refers to a position created by the grant, an upgrade refers to a position that previously existed, but due to the grant funding was able to have an increase in hours. As an example, you may have a part-time social worker who became a full-time social worker through the grant funding. Please note here that an upgrade does not refer to a salary increase that is not associated with an increase in hours. And the last option here on contract means, of course, that the position is listed in the budget under the contracted/consultant heading rather than under the personnel heading. Step 4, indicate whether this position provides IR. Step 5, enter the total number of Article 10 and TPR petitions closed in which the position provided services. Step 6, if relevant, you would do the same thing for IR as you just did for the Article 10s and report the total number of IRs closed in which the position provided services. I included this slide here for the grant-funded attorney positions as well, but we won't review it as it follows the same exact principles as the question about specialized services. But for your reference, I did include a separate breakdown of the steps for you to go back to for the attorney question as well. Okay, are there any questions?
There are no questions in the chat.
Okay, thank you. In the last section on the PRR-195, we come to the fourth grant theme, which is training. Number 42 on the PRR is a screener question, and it asks whether your office has funding under the grant for trainings and continuing legal education. For this question, you'll once again refer to your budget and look under OTPS, and you can scan for terms such as CLEs, training/convenings. Again, if you have this in your budget but have not utilized it yet, you should still respond yes, and then you'll proceed to the remainder of the section. Otherwise, you'll say no and you'll skip the section entirely. So that concludes the content for today's training. We covered the process of reporting and the key components of the PRR-195, as well as those core data points for IR, such as IR, caseloads, interdisciplinary representation, and training. I know that was a lot of information, and you may still be kind of processing it and thinking about your questions, but if you don't have any right now, I welcome and encourage you to follow up as those questions do come up. Looking to the future, individual links to complete the PRR-195 will be emailed out to each provider in January. So we still have a ways to go, but those links will come from the Family Court Data inbox. And again, the first report is due March 2nd, 2026, and will cover calendar year 2025. This is my contact information here. Are there any last minute questions?
I believe there may be one question forming.
Okay. I'll give it a few minutes.
Yes, thank you. Okay, the question is from Robert Brown. Under the grant funded position section, if the attorney is not funded, do we count it?
So I'm hearing that if the attorney is not funded under the grant, like it's not a grant funded position, and if that's the case, you would not count it. The questions about positions are specifically in regards to the grant funded positions in the budget.
He said, perfect, thank you.
You're welcome. I'll give it a few more minutes if anyone else wants to ask a question. So I'm not seeing any other questions in the chat, but thank you all so much for coming today. I really appreciate it, and I'm here to answer any questions that do come up, so do feel free to reach out. And also I'm here for individual data collection meetings as well, so I'm happy to schedule those. All right, thank you all. Take care.